And the Court of Appeal on Tuesday proposed an amendment to the Electoral Act that would allow a governor to be sworn in and nominate a new running mate if their deputy is disqualified by a court. The proposal comes in the wake of the Supreme Court's February 13, 2020 decision to sack David Lyon of the All Progressives Congress as governor-elect of Bayelsa State just 24 hours before his inauguration. Lyon's election was nullified after his deputy, Bio Barakuma Degi Iremioyo, was found to have submitted false information to the Independent National Electoral Commission. During a 3-day retreat on amendments to the 1999 Constitution and the Electoral Act 2022, the Appellate Court called on the National Assembly to address this anomaly to ensure smoother transition of power in the future. Now to discuss this live with us, we are joined by a legal practitioner, Vincent Ottaokpukpu. Vincent, you're welcome. Thank you for joining us.
Thank you for having me. Thank you.
Now, Vincent, let's begin. How would the proposed amendment address the anomaly in the current Electoral Act as we see it?
Yes, the proposed amendment is a welcome development, and we have much expected it because of kind of injustice being suffered by elected governors whose deputies may have a care leg. As you have stated in the case of Degi's case. Degi's case was, a departure from what we used to know. And the case laws are there, but there should be a process of amendment of the provisions of the Constitution. Section 187 per se, which the Court of Appeal in the 3-day retreat has called for further amendment, one provides that a person to the office of governor of a state shall not be deemed to have been duly nominated to such office unless he has by himself a running mate who shall occupy the office of the deputy governor of the state. And the election, when a person has been duly elected to the office of governor, mutatis mutandis, the deputy governor is also deemed to have been duly elected. So this provision in the section 187 and the provides to section 187 also provides that reference to the governor qualification, oath of office, oath of allegiance, and the qualification to that of a governor is mutatis mutandis, deemed to apply to that of deputy governor as the case may be. So the amendment being proposed by the Court of Appeal in the retreat just is quite expected. It will go a long way to assist the judiciary in the interpretative approach to the provisions of the Constitution and deliver justice to the people of Nigeria and to the occupant of those offices, those governors. Because what happened in Degi's case, there was an application to challenge the nomination of the deputy governor for multiple names subscribed on his Form CS001, which is now from EC9 submitted to INEC, which have affidavit of personal particulars. And it appeared that the man has multiple names, which tends to breach the provisions of the Constitution, and the court nullified the exercise. By the provision of Section 177 of the Constitution, there are qualifications listed for a person to be validly elected, qualified for the office of governor of a state. And that Section 182 also provided for disqualification of a person to the office of governor of a state. But it suffices to say that the law are there were provided as per the what happens to the office of governor or deputy governor of a state in case of when the nomination has been the polls have not been conducted, like Section 34 of the Electoral Act 2022 have laconically and copiously provided sub 1 that after the nomination of a candidate by a political party before the poll, a candidate dies, that the running mate shall take over, the political party shall conduct a primary election within 14 days and submit list to INEC. But subsection 2 says that in the case of a governor, if after the poll has been conducted and the candidate dies, but before declaration of results and the declaration of the candidate as winner and the announcement of results, that the INEC should, within 21 days, appoint a date for conduct of election. But in the case of presidential election and governorship election, that the deputy or running mate shall continue to run as the candidate of the party and who will now nominate a candidate as his own running mate. This goes to remedy the situation you had in Kogi State in 2015, where Ottaokpukpu, the then governorship candidate of APC, who was leading with the majority number of votes during the poll, died before the declaration of result. Faleke, the running mate, anticipated that he should step into the shoe and continue, but the APC conducted primary and Yahaya Bello, who came second in the primary election, with Audu, was nominated to be the governorship candidate. So in this context,
Vincent,
yes, I'm coming.
Okay, if you would round up. I've got a very critical question to ask, but go ahead and round up, please.
Okay, I just round up. So in this context now, beyond what I have said, Section 181 of the Constitution has also provided a similar provision which says, sub 1, that where a person elected to the office of governor before taking oath of office and allegiance dies, that the deputy governor shall nominate a running mate, shall be sworn in as governor, who shall nominate a running mate with simple majority of the state assembly. But in sub 2, it says that if the governor or deputy governorship candidate dies before the inauguration of the assembly, that the INEC shall conduct fresh election for call for fresh nomination. So for the proposed amendment, proposed by the Court of Appeal is welcome development, because you see in most cases that the court and the tribunals has nullified the election even after the swearing in of the governorship candidate. And this will assist them to be able to pick another candidate as the case may be, without affecting their office as the case may be. So to remedy the injustice done to Degi, because I believe that a great injustice was done to Degi for a fault of not of his, because there is no provision in the Constitution that has to do with qualification of a deputy governor. It's only provided for Section 177 qualification and disqualification of a governorship candidate under Section 177 and 182 of the Constitution. But whereas that of a deputy governor, Section 187, which have proposed for further amendment by the Court of Appeal, only provided that there is only one ship that carries the deputy governorship candidate who has to nominate a running mate.
All right, Vincent. Apologies if I was trying to stop you from earlier, but I wanted you to put it in a layman's term for the sake of our viewers regarding what happens if, in the case of a disqualification of the deputy governor or the governor-elect or governorship candidates under the proposed amendment. You slightly touched on that, but if you can expand on that more.
Yes, what we have contained in our law today, after the scenario in Ottaokpukpu's case in Kogi State, I have cited Section 34 of the Constitution. Sub 1 says that after the nomination has been closed by political parties, after political party primaries, and they submitted names of the candidate to INEC, and the candidate dies, that the chief returning officer, electoral officer, shall countermand, and after ascertainment that there is an actual death, that should appoint within 14 days for new primaries to be conducted by political party and the candidate be given to INEC to represent the political party. But sub 2 says that if after the election has been conducted, like in Kogi's case, Audu's case, election has been commenced, but before declaration and announcement of result, a candidate dies, that INEC shall ascertain that the cause of death and the actual death, and within 21 days, fix a date for another election. But provides to say, but provided that in the case of presidential election under sub 2 of Section 34 of the Constitution, presidential election and governorship election, that the running mate shall continue to occupy the position as the governorship candidate of the party, and nominate a fresh running mate who occupy the office of the deputy governor of the state. Now, Section 181, I have also said here about the Constitution, provided that if after the election and the declaration has been made and returned, someone has been declared winner with the deputy governor, and the governorship candidate dies, that the deputy governor, before oath of office and allegiance, that the deputy governorship candidate shall be sworn in as the governor, who shall now nominate a candidate as the running mate with the approval of simple majority approvals of the State Assembly. Then sub 2 of Section 181 of the Constitution says that in the case that the governorship candidate who have been declared winner, elected and deputy governorship dies, two of them together, God forbid, that before the inauguration of the House of Assembly, that the INEC shall conduct election, fresh election with fresh candidate and what have you. Now, so these are the provisions of what they have in the Constitution.
Okay, then,
and
Vincent.
For David's case, why it affected David is that there's no provision as to qualification and disqualification of a governor, of deputy governorship of a state.
Vincent.
So the proposed amendment will go along with that assists the governors where their election has been nullified by a court of law to quickly nominate candidates as the case may be, who without losing their seat, as in David's case.
Vincent,
so that will go to strengthen
we would love to let you continue. Would love to let you continue, but we are running out of time, and we're on a schedule here. But thank you very much, Vincent, for your very in-depth explanation of the current process. Thank you very much.